Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly community conference call. Today is October 11th. We could not have one 2 weeks ago because I was doing a conference call for our existing clients for certain new changes that were either already being implemented in immigration law or were on the horizon. So I had to skip our last call. I've got 20 questions for today. I think I have enough. But if we have time, I would be happy to take any new questions I might have. I was not able to join you on time. I was finishing up another call. Luckily, that's over. So now I can go over the questions. I haven't had the time to review them before, so I might be a little slow. But we'll go over these questions one by one. And as I am reading the questions and answering them, if you have any related question, please don't ask new questions, but any related or follow-up question, feel free to press *5 on your phone. If you press *5, I can see your hand raised up and I can answer the related questions as we go along. Let's see. First one is from Srikala. Started my employment in 2008, 2 years, working with the current employer since December 2010. They had applied for and got an approved I-140 under EB1 category in 2014. Very good. I've been getting H1B extensions based on my approved I-140. Current H1B expires 2019, August 2019. If I now receive a new job offer, can my new employer file for a transfer of H1B without filing an I-140? Yes, they can. Remember that because you have an I-140 approval, that I-140 approval, if your dates are backed up, entitles you to a 3-year extension through any employer. And they don't have to, the new employer doesn't have to file an I-140 right away. They can do it in their own good time. But your H1B extension will be based upon the already approved I-140. This is true even if the old employer revokes the I-140, as long as the I-140 stayed approved for 180 days. Okay, so even if they revoke the I-140, you still are okay. With less than 1 year, there is a follow-up question. Let me just finish all of them. I'll get to you in 1 second. With less than 1 year on my H1B, is there sufficient time to complete the labor certification? Yes, but if you are an EB1A, you don't even have to worry about that because EB1A can change jobs and they don't have to start the green card again. But if you're an EB1B or EB1C, things could be different. But yes, there is enough time. Can you describe the steps for the transfer? Just the H1B transfer. There's nothing else. How soon can I start? As soon as you file the application, you can start working. I don't see why you need to cancel these plans. You have to travel because under the law, when you have a transfer pending or an amendment or an extension of an H1B, you can travel as long as you have a visa stamp on your passport. If you don't have an H1B visa stamp, that could be problematic. Okay, there are 2 people with follow-up questions. Let's see. The first one is from Scranton, Pennsylvania, and the other one is from Colorado. So let's see if we can. Pennsylvania. Go ahead, please. Pennsylvania.
Hi, Rajiv. Good afternoon.
Good afternoon.
I understand that you told if you do 140 to new employer, then green card doesn't need to start if they are like EB1.
Right.
But for EB2 and EB3, I understand that we need to do 140 refiling again for the green card, and
actually,
if that is true, then
actually,
what is the difference?
Actually, you have to start from PERM. If you are an EB2 or EB3, you've got to start your green card all over again, but your green card will carry the same priority date as the old case. Okay.
How about the company is some other company bought the same company?
Okay.
In such situation?
That is a much more complicated question. If the transaction was structured in the right way, then the new company can come and take over the green cards and the H1B. but already approved already approved I-140s have to be filed again. Only the I-140.
Okay. Thank you.
You're welcome. All right, let's go on to the next one. And that's Colorado. Colorado, go ahead, please. Colorado. Oh, I did. Oh, maybe I did not. 1 second. What happened? No, I think they put their hand down. Okay. I guess their question got answered. All right. So, oh no, there is another one still left. Oh, Colorado is back up. Okay. Yeah, Colorado, go ahead, please. I can hear you. Colorado.
Hi, Rajiv. Thank you. Actually, you mentioned that even if the I-140 gets revoked, we still be able to get H1B extensions, right?
Yes, if it is revoked by the employer. The only time you won't get it is if it is revoked by the USCIS for fraud, misrepresentation, or some kind of a gross error.
Okay, and is there anything like before 2017 or after 2017, anything that applies?
Yes,
or just,
yes. The regulations that became effective, I think it was 17th January 2017, said that beginning today, if your I-140 has been pending and stayed approved for 180 days, you are good. You don't have to worry about anything. And let's say even if your I-140 was filed in 2016, but on January 17th, 2017, it was pending for 180 days, or it became pending for 180 days in February, you are safe. Because the 180-day period does not have to begin on January 17th. It just, the I-140 should stay approved for 180 days. Any one of those days can fall on January 17th.
Okay, if it is revoked before 2017,
then it's a lot more complicated. I think you can still argue for it, but I think it's a lot less certain than if it was revoked after January 17th. Okay?
Okay.
Good
Yeah,
luck.
thank you.
You're welcome. Okay, let's go on to the next question. This is from Shantanu. Nice picture, Shantanu. All suit and goggles and everything. Okay. Question regarding EB1. You did your MS here with a major bank. You joined a fintech product software company. You've got the EB2 approved, but now you're a senior technical manager. Well, congratulations. You're managing a team of software professionals. They sent you to London, and you plan to come back in 2019, filing under EB1C. So you had some questions. Can I use my priority date of 2015? Absolutely. Yes, you can. When could I actually file the I-485? That depends when the EB1 dates are current. Are there any issues in filing EB1C from H1B? Of course not. You can file it from H1B. I prefer L1A for several reasons. The most important one is L1A has no salary requirements. It is a lot easier to get approved in certain cases where you have a clear-cut case for international manager. So depending upon the case, but there is no requirement that you have to be on H1B. I prefer L1As, like I said, for several reasons, but it doesn't have to be like that. *5 if you have a follow-up question. *5. Okay, let me go on to the next one. From Dr. Tom, I have few queries regarding H visa. H4 and H4EAD are filed together, pending for 1.5 months. Now, if I change my employer and they'll start H1B transfer, what will happen to the previously applied H4 and H4EAD? Do I need to call the application off and file via a new employer again? Or can the application continue to be in process? Does changing employer automatically cancel revoke previous H1B petition, or the employer has to revoke? Does previous employer have to notify ex-employee about the revoke request? Okay, the last two are easier to answer. The other questions are a little complicated. I'm not sure I even understand them, but we can try. First of all, changing employers does not automatically cancel your previous H1B. It has to be revoked by the employer. Do they have to notify the employee before they revoke? The answer is yes, they should. If you look at the Department of Labor guidelines, one of the requirements is that the employer must definitively inform employee, not about the revocation, but that the job is over. I'm not sure there is any law that says they have to inform you that they're revoking, but they do have to inform you that your job is over, and that should operate as a notice that they're going to revoke the H1. But there is no requirement that I know of where they have to inform you about the revocation. The other three questions are a lot more complicated. Some of them I'm not quite sure what you're asking me. So it looks like you were on H1B. I don't know if you are continuing to be on H1B. Star 5 if you are here, so I can talk with you, because I'm not sure I follow your situation. Press star 5 if you are here. Okay, I'll make my best guess about what you're asking me. Obviously the answer is not accurate because I don't know what the situation is. I'm assuming that you're currently on H1, and I'm assuming that you had filed an H4 and EAD together, but you continued to work on H1. Okay, assuming that to be the scenario, you should withdraw the H4 and H4 EAD at some point of time, because if your H1 gets approved, the transfer, and then the H4 EAD get approved, you will be in H4 status, not in H1. So yes, you should withdraw that. Okay, especially because Trump administration has said they are going to try to discontinue the H4 EADs anyway. Makes sense not to depend upon that. Star 5 if you have any follow-up questions on that. Anyone has a follow-up question on that? Okay. Next one is from Soumya Narayanan. My employer filed my green card, labor and I-140 is approved. Priority date 2016. They are not sharing the I-140 approved certificate. It's a company document they don't want to share. If I apply for Freedom of Information Act request, okay, so there are a few things here, Narayanan. You should definitely apply for Freedom of Information Act request, and even if they don't give you a copy of the I-140, you should be able to still port the priority date. We've had cases where we didn't have a copy of the I-140 approval notice, but we were still able to port the priority date, because what happens is, upon approval of the I-140, the priority date becomes your property. Government automatically assigns it to you. You don't really have to produce any documentation. It's just easier if you have it, but it's not required. Okay, so even for H1B transfer, we have used just the name of the employer and the name of the employee with their social security number, and we've been able to get H1B extensions and also I-140 priority date transfers. But definitely apply for Freedom of Information Act request. Star 5 if you have a follow-up question on this. Star 5. Okay. New Andhra says, I'm working on AC21 EAD. Priority date is 2010, not with the sponsored employer. Can I file a new EB3 or downgrade the EB2 to EB3? Well, you will not be able to downgrade because you're not working with the same employer. But yeah, definitely you can file another case, an EB3 case. And you do need the same employer who sponsored your EB2 to downgrade to EB3. But if you have a new employer, you can start an entirely new EB3 case. Okay. Star 5 if you have a follow-up question on this. *5. All right. Grateful 516 is a permanent resident, married for 2 years. She's living with her husband for 7 years. He's a student. Can I sponsor him? Of course you can. You are working, he's an F1 student, never been unlawful. Yes, you can. The only thing is, when you have a green card application pending and you're on a student visa, you shouldn't travel. Traveling outside the USA would be a bad idea. But other than that, I don't see any problem in applying for a green card for your spouse. *5 if you have a follow-up question. *5. Okay. Let's go on to the next question from Arpit Seth. My H1B extension got rejected. You've gotten converted to H4. I still have 15 months on my H1B, 6 years. Is it possible for any other employer to file cap exempt H1B? Oh, absolutely. Absolutely no problem. Can any other employer file my cap exempt new H1B after 1 year? Yes, ma'am. The way it works is if you have been approved any time in the past 6 years, you can continue extending your H1B outside the cap. So yeah, you will be cap exempt. If I'm on H4 but within USA, can I get 6 more years of H1B? No. You have to be physically outside the United States to get 6 years of H1B clock reset. And by the way, then you'll also be subject to the quota. *5 if you have a follow-up question on this. *5. Okay. Just to remind everyone, you can press *5 to ask a follow-up question. Ruchi says, I converted to H4 because my H1B extension got denied. Somebody else is filing an H1B extension for me. 1 year is still remaining. Will my H1B be filed first and change of status? No. It's all filed at the same time. And you can't file premium because they have discontinued premium. So until February, when they might reinstate it. I have a follow-up question from someone. So, oh no, there's 2 people with follow-up question. So let's see whom we can get. Okay, let's see. We've got Colorado. Colorado, go ahead, please. Colorado.
Thank you, Rajiv.
Sure.
So you said if we are outside of the States for 1 year, then the clock is reset, right, after 6 years period.
Right.
So, I was outside of the US after my 6 years, and I came back on H4 after that. And can I now apply, because I am in US after that for more than 2 years now? Can I apply in next year quota?
Of course. If you were outside USA, your clock got reset at that time. The fact that you're on H4 does not interrupt that clock. As long as you are outside USA for 366 days, you've got 6 years of H1 now, and you can apply under the quota again, no problem.
And I was on 7th year extension that I had a valid visa, but I was outside of US. Still, I can apply for quota.
Yeah, ma'am. As long as you're physically outside the USA, whether you have an H1, H4, whatever, doesn't matter, because the physical presence outside makes you eligible for 6 more years.
Okay.
All right.
Thank you.
Oh, you're welcome. Okay. So let's see. Next one is from, this is from somebody who doesn't have a caller ID, so I can't tell where you're from. Anonymous, go ahead. I can hear you.
Yeah. Hi Rajiv, this is Arpit. I'm sorry my system got hanged. I couldn't request a question for the previous one. I mean,
no problem. I got you.
Okay. Okay, thank you.
Yeah, of course. You got rejected. You have 15 months on your H1B. Can somebody else?
Yeah, my only question.
That's a simple.
For the first.
Yeah, that's a simple.
Yeah, for the first one was, I mean, now that I mean, now that I am a valid, I have a valid status of H4, can new employer can file a new H1?
Oh, absolutely.
Because initially,
yes, they can,
okay,
and you are not subject to the quota.
Not subject to the quota. And till what time? I mean, this can be done. I mean, let's say
6 years. Arpit, 6 years. 6 years. For the next 6 years,
okay,
you can apply for an H1 anytime without going to the quota.
Okay, 6 years from the rejection. Is that what you meant?
I would say, look, this is a little complicated. The statute says you are exempt from the H1B quota if your H1B has been approved anytime in the last 6 years. Okay.
Okay.
So the worst case scenario from 6 years from the date of your last approval, but the way USCIS interpreted it is not from the date of the approval, from the date of the continuation. So if your H1 was approved in 2015, but you discontinued in 2017, under the current policy, you should be able to apply anytime till 2023, 6 years from the date of discontinuation. And even in the strictest circumstances, it would be from the date of the approval. So you got plenty of time.
Okay.
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 Good.
Thank you.
You're welcome. Okay. Now let's see. We have one more question. All right. This one is from North Carolina. North Carolina, go ahead, please. I can hear you.
Hi. Thanks, Rajiv, for answering my question. This is Ruchi.
Ruchi.
So you said that anybody can apply for H1B. So once I'm at approved H4, so when the H1B gets applied, can I just start working immediately, or there will be
No. You see, in order for you to start working immediately under AC21, you have to be on H1B. So you convert it to H4, now you are no longer on H1B. So even though you're not subject to the quota, you can't start working right away until the H1B is approved. And just for your information, government had said that they will reinstate premium processing of H1B in February. So that means even if you apply now, probably in February you'll be able to premium the pending case.
And once it gets approved, I can start work?
Yes, ma'am.
So there is no COS required. Automatically my status.
No, you will need COS, but COS is H4 to H1 COS. I don't know how that could be denied.
Okay.
Okay.
So you mean the petition would go in the same format, like a new project plus the COS would happen in the same amendment, and then it will get
that is correct.
And then I can start work.
Yes, ma'am. That is correct. Okay.
Okay. The concern was whether there will be any other delay time after the H1.
No.
So I just want to make sure.
Yeah, okay. No. Everything else is okay. All right.
Okay. Thank you, sir.
Oh, you're welcome. Bye-bye. Okay. Let's go on to the next question. And this is from Gokul Srivastava. Guys, I didn't get a chance to review the questions beforehand. So I'm a little slow today because I'm reading them as we go along. But bear with me. We'll get through them all. We are almost halfway done. So Gokul Srivastava says, I'm on H1B for company A, consulting firm. Project is coming to an end in a week's time. I got an offer from company B and I'll be joining them on H1B transfer. H1B approval received for company B. Okay. Company A told me that they will not cancel my H1B. I want to work for company B. Can I go back to company A? So I guess that's your question. After 2 months, can I come back and work for company A for a new project in a different location with H1B? And the answer is, yeah, you can. The regulations, the new regulations that came out last year in January actually allow that you can go back. However, there is a conflicting regulation that makes it incumbent upon the employer to revoke the H1 if you're not working for them. Otherwise, they are liable to pay you your salary. So it's a very weird situation where one regulation allows you to go back and join the old employer. Another policy, if not regulation, says that the old employer should revoke your H1, otherwise they are liable to pay you your salary. So it's a strange situation. But to answer your question, can I go back and join them? Yes, you can. Are they required to revoke the H1? Yes, they are. And how long can they keep your H1 active? I don't think that's something you should test or the employer would test. If I were representing the employer, I would have to tell them, listen, folks, you have to withdraw or revoke the H1. They can always refile it if you ever plan to come back, but keeping it open is risky for the company, not risky for you. *5 if you have a follow-up question on this. *5. Okay, Prasad Gupta says, I have a priority date of 2009. EB3 and EB2 are both approved from the same employer. Attorney said you could file 485 whichever category became current. Now they are saying they need to make a determination whether they can file or not. EB3 was a generic designation as a software engineer, and EB2 was filed as a staff software engineer in quality. Well, this is a difficult question for me to answer, because whether or not you can file depends upon whether or not the EB3 job is available. So if the EB3 job is open and available, you can definitely file under EB3. And if you are asked, why do you have 2 green cards going, although they have never asked this question, but if they do ask, as long as both filings were made in good faith, honestly, without any desire to cheat the government or to try to misrepresent anything, I don't see any problem at all with that. Can you switch back to EB2? And the answer is yes, you can. When you have 2 cases approved, about a week ago, they were in a panel, American Immigration Law Association panel, where this question was asked, and the government said, look, we automatically assign to you, if we have 2 cases pending for an employee, we automatically assign to them the most advantageous I-140. So even if you have filed an EB3 I-140 and EB2 I-140 is also approved, we'll give you that automatically. But it would be nice if you let us know beforehand. So if your dates become current, have your lawyers write to the USCIS saying that we want EB2 now instead of EB3, and also or open a service request just to make sure that they've got you covered. So yeah, this can be done as well. What is my suggestion? It depends. Prasadji, I would have to review both cases and have at least an hour-long review session with you and some few minutes discussing the case before I can make that call for you. But if you have competent lawyers, just sit together with them and figure out if there is any risk in doing this, other than the risk of being hauled up for fraud. As long as you were acting in good faith and everything was done honestly, I would go for it. I don't see why not. The law allows it. Okay. So there is a follow-up question. Let's see. Who is it from? This one is from New York. Yeah, New York, I can hear you. Go ahead, please.
Hi, my case is also pretty much similar.
Okay.
My priority date is August 2009.
All right.
So I also consulted another attorney,
right,
and they said it depends on the job requirement for EB3 versus EB2, and if you see the one filed under EB3, the job requirement had had only 2 years of relevant experience with no minimum qualification. With EB3, since it was filed like 6 years later, EB2, it was filed, 140 was filed 6 years later, the job requirement were changed. So now,
I
because
disagree.
we have both the I-1...
I disagree. I think the important thing is, like I said, you acted in good faith, and the company is willing to put you back in the EB3 category job, and you are willing to take that job as and when the green card is approved. I don't see any reason why you can't go forward. But of course, somebody who's looked at your paperwork can guide you better. But my guess would be, as long as you acted in good faith, as long as both jobs are available and you plan to take the step down job, why not? It's your choice.
Okay.
Okay.
And do you see, from the retrogression standpoint, EB3 going back, and then I mean, I'm a little concerned that
I can't comment on that. I don't know what's going to happen. Nobody can really predict that. But I think both options are equally available to you.
So any recommendation, Rajiv, since EB2 dates are pretty much like we are close.
I believe in being conservative but not timid. So if the law is on your side, I don't see why you should not take full advantage and full benefit of the law. As long as, like I said, you acted in good faith, go for it. But if there is something in your background that worries you, that should be discussed with a lawyer, your company's lawyers, or somebody who can look over the paperwork. But as a matter of principle or in theory, I don't see any problem with going with either or both options.
Okay.
All right.
Thank you.
You're welcome. Okay, so let's go on to the next question. This one is from Venkat KVPBSI. Venkat says, working for this company since 2007, EB3 in 2009, I-140 approved, priority date is 2009. They also filed a PERM EB2 in 2014. Company got acquired by another company and they continued the EB2 process. Can I use my EB3 to file change of status? We just discussed that. So just listen to the discussion so far that we have had, the last two questions. But you have a follow-up question. Can I use my EB3 to file change of status by using successor in interest? And the answer is probably not. Because at some point the government has started saying that if there is a successor in interest, they should still, if you have an approved I-140, like in EB3 case, they have to refile the I-140. So they do have to file the I-140 again. And you won't get premium processing in this case. Okay. *5 if you have a follow-up question. Oh, I'm sorry. Yeah, that's all you had. Okay. So this is from California. Yeah, California, go ahead, please.
Sir Rajiv, this is Venkat here. Thank you for answering the question.
Yes, sir.
What you're saying is basically because the new company acquired the old company which was done, basically my EB3 was done, I have to have a new I-140?
Right. What the government says is, if there is an approved I-140 and the company gets acquired through successor in interest, they have to redo the I-140, not the PERM, just the I-140. If the company is not a successor in interest, then they have to redo the entire green card.
Got it. So right now there is no premium process that will take time as well, I guess.
Yeah, that'll take a few months for sure. But if your priority dates are current, sir, I don't see why you cannot file I-140 quote-unquote amendment and 485 together.
Okay, that's one other option.
Yeah, you can double check with the USCIS, but I believe it can be done. I think that's what we are doing.
Okay, got it. Another question you answered for Prasad was basically saying, we can have both EB3 and EB2 can be done in parallel.
Why not?
If EB2 becomes current down the line.
Why not? Absolutely.
Okay, great.
Okay.
Thank you. Thank you for asking my question.
You're welcome. Bye-bye. Oh, one more thing I wanted to add. I have even gotten approvals. Let's say I got the EB2 approval for somebody. I use the same I-140 and file for EB3 also. So
sorry, so can you repeat that?
Yeah, so let's say I got your PERM approved under EB2. Okay.
Right.
I've got the I-140 approval under EB2. I can use a copy of the same perm and get you approval under EB3 also.
Got it. Got it.
Okay.
One quick question, though. One last question.
Sure.
When the EB2 140 was approved, the date was pulled over from EB3. That should not disturb the EB3.
Yeah, a date is not kind of like something that gets expired because it has been used once. It stays yours forever. It can be changed and transferred to as many cases as you like.
But that should not impact EB3 at all, right?
Not
because the date is poured out
not
EB2.
Porting of the date does not render the previous approval defunct.
Okay.
Okay.
So the previous EB3 stays intact.
It stays completely intact. No question about it.
Got it. Thank you very much.
You're welcome. Good luck. Okay. Now we go on to the next question. This is from Roy Job. I started working here from 2015 with an L1. I don't know if it's an L1A or L1B. Okay. While I was working with my company, I filed an H1 with consulting company in 2017. There was an RFE about the wage level, etc., etc. Okay, that response was received on November 1st, 2017. No updates since then. Unfortunately, I lost my job, and I had to come back to USA on H4. My employer said they haven't received the denial letter. It's going to be a denial. They are not pushing for premium processing. What is the right way to approach USAS? You don't have to, Roy, you don't have to do anything because you are currently on H4 status, and if the case gets rejected, there is no problem. You can just file under the April quota for another H1. If you get through, great. The pending case, even if the case is still pending, it doesn't affect you in any way. So I don't see any problem here. *5 if you have a follow-up question. Okay. Let's go on to Matthew. Okay, so here are a few numbers on my case. Working with this employer since 2011 on H1B. EB3 was started in 2016. I-140 was approved June 2017. Priority is December 2016. So I'm good till 2020 on my H1B. I have not yet filed I-485. As I was preparing the 485, I came to know that the company employer has been operating at a loss for 2017 and 2018. So there's a negative net annual income. You've been paid the proffered salary. Okay, so whatever the green card salary is, you're already getting paid. That's tricky. I don't know how this is going to play out. This is very largely a question of particulars of the case. The inquiry on supplement J is likely to be less rigorous than an inquiry on the I-140 if you had an ability to pay wages issue. So I don't know what the answer to this situation is, but if you have been getting paid more than the wage promised under green card, I think you should be fine. Am I eligible for job portability under AC-21? No. Until you file 485 and 485 has been pending 180 days, you cannot get job portability. What is safer? I think you should, I don't know the case. Why are they showing negative income? Is it just good tax planning, or do they have a problem? I cannot predict that, but if everything else were equal, it certainly makes sense because you're not entitled to AC-21. Take a chance. Let's see how you work out with this negative income situation, whether you can get through. I think you'll be able to, but that's my guess. *5 if you have a follow-up question. *5. Okay. So let's see.
Thank you, Rajiv, for the answer. So there was something that I missed inserting in there.
Okay.
My salary actually was lowered as well. I mean, after some time.
Okay.
So at the moment, so there were 3 wages. The prevailing wage at 70, LCA current salary 75, but in the I-129 petition for the H1B extension.
Hang on one second. Hang on one second. You become safe only if all through this process you were paid your green card salary. Okay. If you are not getting paid green card salary, your fight is likely to be a lot tougher.
Okay, I see.
So
yes, I have not been that.
I think in your situation it makes more sense, or at least something worth considering. Let me think about this. So if you get denied or green card is terminated, can you still carry your priority date? That's definitely a question that's up in the air. I don't know. I have an answer to that. So if on the other hand, you just move over to a new employer, start your green card all over again, take the priority date of the old case and apply for 85, I think you're pretty safe in that case. Okay.
Okay, could I ask one more question that I've been on concern lately?
Sure.
Have I violated the terms of my H1B extension if my salary has been lowered below what was in the I-29
Yes.
or the LCA?
Yes. You have violated the H1.
Is there?
But have you been outside USA since then?
No, I have not.
Okay. You need to, this is a lengthy and complicated issue, but you need to file a complaint against the employer. They should pay you for the shortfall. They're not allowed to do that. And that also becomes a good defense against violation of status.
Okay, does that mean that I have to leave my employer? Because we have very good relations, work relations, and I wouldn't want to...
They should go back and pay you.
Okay.
Okay. And at least you have some argument that they made up for that money, even though they didn't pay me. It's still a technical violation of your H1, but at least there is some possibility you'll be able to raise some good defenses against willful violation of status. Okay.
And could I still continue the process with the same employer?
Yeah, that
after doing that complaint?
That I think is a little doubtful. When you have a break in payments, that does not bode well for the employer's ability to pay wages.
Okay. All right. Thank you.
You're welcome.
Thank you so much.
You're welcome. Good luck. Next question is from Hira, reply 580. Currently in my 7th year of H1B with approved I-140 from current employer. I-129 extension I-94 got expired August 2018. Can I get a new job with a new employer? So you have an extension pending. Well, the answer is yes, but if the pending case gets denied, the government can make you go outside for visa stamping. The bridge petitions can fall down if any one link of the bridge collapses. So you have one case pending, but the old status has expired. You file another transfer, and if that intervening link of the extension, pending extension drops, then if the H1B is approved, it will be approved with a visa outside USA. *5 if you have a follow-up question. Okay. Abhi 23 says, I've been in the US since 2006, H1 2009, approved I-140 from previous employer. Current employer is giving me an opportunity for long-term assignment for 2 years in Taiwan. Can I be outside USA while on US payroll? Of course. Can I apply for H1 again based upon the previously approved I-140? Yes, and I think you'll be cap exempt. *5 if you have a follow-up question on this. Jalak 1420, Currently on L1B, valid till 2019. I want to go out of USA for L1B renewal to US consulate. Is this considered an L1 renewal or fresh application? I don't know what the fees is going to be, sir. I'm sorry. I don't keep track of the fees. My husband has EAD, ma'am, my husband has EAD till Jan. We wanted to apply EAD extension till March. Do we select renewal in ISM? I don't help fill forms either, ma'am. Because if I help you fill form, then I have to sign the form. If they reject my applied L1B, oh yeah, they can cancel your existing visa. They don't always do that, but they can definitely cancel the existing visa as well. *5 if you have a follow-up question. Okay. Then we come to Kumar_BLR. I-140 was approved in Feb 2017 with Company A. Was active for more than 180 days. Good. Got my 7th year extension and traveled. You should have gotten, if you had I-140 approval, you should have gotten 3-year extension. Returned to India in beginning of 2018 due to client business closed. Haven't traveled back. Now I've decided to quit Company A. Like to join Company B within India only. Now my question is, can Company B sponsor me on H1B anytime? Yes, they can. Will I be considered under cap exempt? Yeah, if you apply within the 6 years of the last approval. So the answer is yes, you'll be cap exempt and you should be able to get a 3-year H1. Withdrawal of the I-140 should not have any effect on this. Company B would file a new perm. Can I get H1B extensions until then with approved I-140? Yes, but even if it is withdrawn, you should be able to get extensions based upon a withdrawn I-140 through Company A because it stayed alive for more than 180 days, and you'll be able to get extensions for Company B. *5 if you have a follow-up question on this. Okay. Oh, there is a question from somebody anonymous. Voice over IP probably. Go ahead, I can hear you.
Sir, this is Kumar.
Yes,
thanks for answering the question. So my question is, thanks for answering the question. And if the Company A removes the job, what was offered for the green card, while my transfer is happening with the Company B, will that have any effect on getting the extension done?
Repeat that question for me. If the Company A withdraws the H1, is that what you said?
No. If the role that they offered for the future employment, if without informing me, like if that job has become invalid for which they wanted to hire me in the future,
that doesn't matter. If your I-140 was approved and stayed approved for 180 days, you're good to go.
Okay.
All right.
And the Company B can transfer the visa anytime. So my H1 is actually expired, so that doesn't have any impact on
no impact.
Company B transferring my visa, right?
No impact.
Okay. All right.
Good luck, sir.
Okay. Thank you very much for that.
You're welcome. Okay, let's go on to This is our second last question. Guys, I won't have time for new questions, so we'll just finish the ones that we have and any follow-ups on that. Doc Jads says, I filed my I-140 in Jan 2017, 485 rest of the world in March 2017. I have not changed my employers in the last 4 years. In my perm, the salary should be X plus Y is equal to Z dollars. For the last 5 years, I'm making X dollars as per my H1B. I'm on EAD with the same employer. H1 is expired. The employer has enough funds to pay me X plus Y is equal to Z, and they'll start the new amount after the approval of the 485. I don't see any problem with that because the green card salary has to start only after approval of the 485. It can start earlier, but it's not required to. Before 485, you are required only to be paid the H1B salary. And when you are on EAD, I'm not even sure that's a requirement, but I think you should be paid as highly as possible. I don't see any problem. Should I be taking supplement J? I believe so. Let's see. Yeah, because you filed your I-140 and 485 at different times. Supplement J will have to be taken. Carry the adjustment of status sheet will have a bunch of documents they want you to bring with you. Just bring those documents. Question number 3. I have my I-140 approved May 29, 2018. 180 days would end November 2018, early December 2018. Can I change my jobs before November 2018? Yeah, you can. But the only problem is, see, the way this is a little weird, the way the AC21 portability works. I won't have time to describe everything to you, but go ahead and set up a consultation with your own lawyers or with us. I'll try to go through the details with you. But the law doesn't say you have to hold the job for 180 days to enjoy portability. The law only says that your 485 should not be denied before 180 days. So what if you get an RFE when there are 10 days remaining on the 180 days? You're fine, because RFEs are 87-day deadline. So by the time you respond to it, 180 days would have gone by. And even if you change your job on the 100th day, the fact is your I-485 remained unrevoked for 180 days. So you should be okay. Star 5 if you have a follow-up question on this. Can an employer, this is the last question for the day today, folks, and we are right on time. Can an employer retain the original 797 and give a copy to the employee? And the answer is yes. I'm not aware of any requirement that says you have to have an original 797. Is there a way to obtain an original? You won't even need one. Why would you need one? Okay. Star 5 if you have a follow-up question. Star 5. All right, folks, it looks like we are done for the day. Thank you, everyone, and I always enjoy speaking with you. We'll talk again in 2 weeks. Take care, everyone. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.